Today we're going to talk about no contest clauses and how they can be used in your estate plan. My name is Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like what you see today in today's video, please smash that like and subscribe button. It really helps the channel. Today we are going to be talking primarily about Minnesota law as well, though we will be discussing a few other jurisdictions. If you have any questions on this, about your jurisdiction, please contact an attorney where you live and have them help you out. So, what do I mean by a no contest clause? Essentially, a no contest clause is one that says if you contest the will, then you are disinherited. Other names for a no contest clause might be a penalty clause or a forfeiture clause, or my favorite, which is Latin, which is the in terrorem clause. So some people anticipate that their estate is going to be challenged, and this could be for a variety of reasons. For instance, the inheritances given out might not be equal. There might be an expectation of some people that they'll be getting something that you don't want them to get in the end. There's also what I call the girlfriend syndrome. Maybe the decedent is giving someone a large share of the estate that the other beneficiaries don't think that person should have, such as an older man who gets a younger girlfriend or wife and decides to give that person a part of their estate. And sometimes an in terrorem clause might be used just because people of their nature, maybe with lots of money at line, will want to challenge the will. So state laws vary pretty greatly as to whether no contest clauses are enforceable or not. Only to my knowledge, and this may be a few years old, but only to my knowledge, only Indiana and Florida expressly prohibit the use of a no contest clause. I don't think that has changed, but it's possible that it has by now. Minnesota has taken what is known as a pretty common approach. The statute says a provision in a will purporting to penalize an interested person for contesting the will or instituting other proceedings relating to the estate is unenforceable if probable cause exists for instituting proceedings. Most other states have this probable cause standard, and what this basically means that if you challenge the will and you win, then the no contest clause doesn't have any validity. If you lose, but you had a viable reason for bringing a claim against the will or the estate, then the no contest clause also will have no viability. But if you bring a frivolous claim and that didn't have any basis in the beginning, you're going to lose big. So the interesting thing about the Minnesota law, and this is the case in a few jurisdictions, is that the no contest clause doesn't just contest or just not apply to when we're challenging a will outright. It can exist for other proceedings relating to the estate, as the statute says. Now, this can include actions for an accounting of the estate or actions to remove a personal representative. Depending on how you draft the in terrorem clause, these might be viable reasons to disinherit someone. On its face, there's also another limitation to the Minnesota law, in that it only applies to wills and it doesn't apply to trusts. Now, whether you can have an in terrorem clause with the trusts, I don't know. It's a relatively new statute, only drafted in 1996 in Minnesota, and there hasn't been a lot of case law related to no contest clauses, ever. In fact, I did a search and I only found 2 cases where a no contest clause was actually discussed in any depth, and in each case it was only about a paragraph, and in neither of these cases was the no contest clause actually at issue. Other states may have some more precedent, but we just don't know in Minnesota how the courts are going to address no contest clauses. Now, the reason someone might use a no contest clause is there's a variety of reasons that someone might use a no contest clause. First of all, is just to flat out discourage litigation. It makes people think twice before they go and challenge a will. It also discourages frivolous claims. It's more likely that a court will throw out or allow someone to be disinherited and enforce a no contest clause if someone is bringing a bunch of frivolous claims just to slow down the estate or to whatever else. No contest clauses also can help encourage family harmony. You wouldn't think that, but realistically, anytime you jump into litigation, it's going to destroy family harmony. It's a very emotionally draining and financially draining situation that no one wants to go through, and it takes a lot of real estate up in your head. So if you can force people to avoid litigation, it will actually improve family harmony. And lastly, a no contest clause can be used to enforce a spendthrift provision, such as you can have an inheritance of X amount of money if you go to college. You may get something else as well as that, but if someone says, well, I should be able to get that without having to go to college, this is where a no contest clause would come into play and encourage someone to not go through litigation to get their money. Now, there are a couple situations where a no contest clause is pointless. First of all, if someone is already disinherited, there's no threat of disinheriting them because they're already getting nothing. Now, one thing of note, and you should be aware that anytime you want to use an interim clause, you need to close a loophole. And what happens is if someone is being disinherited and somebody else is unhappy with what they're receiving, and there's a no contest clause in place, the person that is receiving something but unhappy could get the other person who's already disinherited to challenge the will without just saying it's their job, basically having a surrogate to challenge the will. Now, the person that isn't happy with what they're getting, they're not technically challenging the will, but the person who's already being disinherited has nothing to lose by challenging the will because they're already disinherited. So if you're going to use a no contest clause, be a little bit creative in your drafting and try to close some of these loopholes. Another time a no contest clause will have no effect is if the will is rescinded by the court as defective. So if, for instance, if the will wasn't executed properly, then the will have no viable grounds for existing. It won't have any enforceability. If the will doesn't have enforceability, then the no contest clause has no enforceability, and it doesn't do any good. So anyone can challenge in that case. So that is basically what a no contest clause is, how they can be used, how they can't be used, and what some of the Minnesota law is on them. I hope you liked today's video. If you did, please feel free to like and subscribe below. It sure helps support the channel, and you'll get notice of every video that we post, which will be every other Wednesday. Also, if you have any questions, leave them in the comments below. I'm happy to answer them. Otherwise, until next time, this is Gregory Singleton with Signature Law.